Welcome to the second instalment of the Trinity Chambers Civil Liberties and Human Rights webinar series. My name is Matthew Crowe, and I'm a Civil Liberties and Human Rights practitioner here at Trinity Chambers. In this webinar, we have three speakers. Simon Goldberg will present a talk on the direction of travel in negligence claims against public authorities, with particular analysis of the recent and topical case of Tindall and the Chief Constable of Thames Valley Police. Shada Mellor will then address the Miscarriage of Justice scheme, and I will give a talk entitled Hamlet Without the Prince, Wrongdoing Without Compensation. Hamlet Without the Prince, of course, describes events in which the expected key component is not present. This is a suitable analogy for a growing category of false imprisonment claims. In recent years, a steady stream of false imprisonment cases have played out in the theatre of the courtroom, in which unlawful conduct has been found, but, unfortunately for the claimants, no compensation followed. This talk therefore explores the circumstances in which Hamlet is performed, but the prince doesn't appear. I will divide this talk into two core chapters. First, nominal damages and the situations in which such an award will be made, despite unlawful conduct. And second, the broader issue of possible inconsequentiality of unlawful decisions to the lawfulness of detention. With those two in mind, I'll turn to nominal damages first. Nominal damages are small sums, often £1, that can be awarded where a tort is committed, but a claimant has suffered no loss. A famous example of this is the case of the art critic John Ruskin and artist James Whistler. In the late 1800s, Ruskin published a letter describing part of Whistler's work in this way. I have seen and heard much of Cockney impudence before now, but never expected to hear a coxcomb ask 200 guineas for flinging a pot of paint in the public's face. Whistler sued for libel. He won. It was a hard-fought and inordinately expensive trial. But that only led to a farthing in damages. The case bankrupted Whistler and destroyed both men. The law in some senses has moved on quite a bit since then. Where a claimant has been falsely imprisoned, a court may award nominal damages where the defendant could and would have detained the claimant in any event. This principle was explored most authoritatively in the 2011 Supreme Court case of Lumber. In Lumber, although the Home Office had a published policy on the circumstances in which detention would be affected, the Secretary of State had applied an unpublished policy alongside it, involving an almost blanket detention on all foreign national prisoners pending deportation. That parallel policy was unlawful, and the claimants had been falsely imprisoned as a consequence. The question for the Supreme Court in Lumber was whether the claimants were entitled to no more than nominal damages had the unlawful act not occurred. As a matter of principle, the Supreme Court found that if an individual was unlawfully detained following a public law error, then they are entitled to nominal damages only if they could and would have been detained in any event. In other words, if the power could have been lawfully exercised, then that's a powerful reason for concluding that the detainee has not suffered any loss. They would have been there in any event. This principle has been applied in a widely publicised case, a 2018 case by the name of Parker and the Chief Constable of Essex. Parker, despite the name, was a case brought by the celebrity entertainer Michael Barrymore about his now infamous arrest. The Court of Appeal in that case found that there were quite plainly grounds to arrest Mr. Barrymore but the way in which it was done was unlawful. It was found by the court that substantial damages would not follow for his false imprisonment, because the police could establish that despite lamentable procedural failings in the case, it still would have taken place in any event. Mr. Barrymore, in other words, suffered no loss, and Mr. Barrymore received nominal damages only. Distilling these cases and the lumber principle reveals two core tenets in this area of law. First, where unlawfulness has been proved by a claimant, causation remains relevant to the question of damages. This is because damages for false imprisonment are meant to compensate the relevant individual for the loss of their liberty. And that person, that claimant, cannot be compensated for the loss of something which they never will have enjoyed. Second, in applying the lumber principle, compensatory damages therefore turn on the question of whether, being able to do so, the public body would have detained the individual irrespective of the unlawful acts or decisions. In other words, the defendant must show, on balance, that the detainee could and would have been detained. It is useful at this point to add some colour to the lumber principle and consider how defendants in other cases have sought to satisfy these principles. In the 2015 case of Bostridge, the defendant NHS Trust used the wrong mental health powers to detain a person. That was unlawful. But had that unlawful act not happened, the claimant would have been in precisely the same position. Nominal damages followed. In the 2013 case of Al Sadoun, the defendant's Secretary of State failed to review the detention regularly as required by her own policy. The defendant produced witness evidence to show that detention could and would have been maintained in any event. Nominal damages again followed. And third and finally, in the 2017 case of Anuga, the same defendant Secretary of State delayed and failed to refer a claimant for medical assessment. This, in that case, was particularly relevant to the decision to continue to detain that person. But the court found, after careful analysis of the evidence, the delay and failure made no real difference. The claimant still would have inevitably stayed in detention. Nominal damages again followed. These three cases all relied on well-reasoned evidence to demonstrate, with some degree of speculation, what would have happened in the case. Be aware, however, there is a caveat. In the 2018 case of Aboro, it was said by Deputy High Court Judge Karen Stein, Queen's Counsel, that the issue of what the defendant would have done had it followed the law need not in fact be evidenced by a witness if the answer is plain from the circumstances. So it is not always a truism to say that well-reasoned witness evidence must be produced on this topic, because in some cases, rare cases, it might be apparent from the facts already before the court. More examples of this principle will follow in the handout that accompanies this talk. But from these few cases that have been discussed, we can see that there are plainly claims in which, despite there being unlawful acts, decisions, and even detention, no compensation arises. I will now move to the second chapter, which addresses unlawful decisions that do not go on to impugn the lawfulness of detention. This is a far more broad and fraught area of the law. But much like the issue of nominal damages, where an unlawful act or decision is established, there must still be a cause and effect analysis by the court to understand where it leads. The recent 2020 case of DN Rwanda and the Secretary of State for the Home Department grappled with this issue. The Supreme Court in that case found that where the Secretary of State had made an invalid deportation order, the unlawfulness of detention which was founded upon that order was inevitably unlawful. In this case, it was found there was no statutory power to detain DN, the claimant, because detention was for the express purpose of facilitating the deportation. And without the existence of an underlying lawful order, detention could not legitimately and lawfully take place. The claimant in DN succeeded. The question that is now developed following that case, in almost every situation involving unlawful decisions and acts, is whether the detention was, as a matter of fact and law, tainted by that unlawful decision or otherwise founded upon that unlawful action. A good analysis of this principle arose in the 2018 High Court case of Sane. The claim in that case was, in short, that detention was unlawful because the claimant's human rights claim for protection was unlawfully certified under statutory power. That statutory power had the effect of declaring that despite an appeal not yet being initiated, that person could still be removed from the country. The court in that case found that the certification of the decision was plainly unlawful. But that, the court found, did not necessarily mean the detention that followed was unlawful. 4 steps were taken in arriving at that view. First, the starting point is that not every breach of public law is sufficient to give rise to a cause of action for false imprisonment. The court said, as was the case in DN, the breach of public law must bear on and be relevant to the decision to detain. Second, the court found that the claimant was detained for the purpose of removing him in accordance with a deportation order. The fact he could not appeal against that order before he left the jurisdiction did not bear directly on the decision to detain or indeed to continue detention. It was arguable, the judge found, that that unlawful decision did bear indirectly to some degree on the detention, but it wasn't founded upon it. The third step was that the case laws, the judge said, generally indicated that in cases of public law errors, the courts have always been able to identify an underlying qualification on the power to detain, as in the case of DN. The detention was predicated on an unlawful decision, but in this case, the court reasoned, it was not. Fourth, in arriving at a conclusion in this case, the court said this, and I quote, "In applying that analysis to the wrongful issue of a Section 94B certificate, it seems to me that the conclusion must be that there is nothing about that section or in the defendant's own policy or guidance to which my attention has been drawn in relation to the making of a decision by her officials whether to issue such a certificate, which can be construed as in any way qualifying the power to detain exercised here. In my judgment, therefore, the wrongful issue of a certificate, whether under Section 94B or Section 94, provides no basis for a contention that the detention or continuing detention of the person in respect of whom such a certificate is issued becomes unlawful." The court in Sane, unpacking that, therefore found that while there was an unlawful decision, that decision did not itself automatically translate into false imprisonment. In summarising the issues in DN and the case of Sané, it is clear that the test will be fact-sensitive. The court will have to ask itself the question, does the unlawful decision bear upon the detention, or is the detention otherwise founded upon an unlawful act? In considering the lawfulness of detention, there may, for example, be a series of successive steps and decisions, each having a potentially independent existence of one another, capable of surviving a break in the chain of causation. To this end, we come back to the same phrase, cause and effect. And overall, in respect of both the issue of nominal damages and the issue of unlawful decisions, compensation, as we have seen, can and may be denied despite unlawful conduct. And in doing so, we see often the prince may not appear in the Hamlet play because compensation may be denied. Thank you.
My name is Simon Goldberg and I'm a barrister at Trinity Chambers. As every law student is taught, the common law develops incrementally on a case-by-case basis. However, some areas of the common law develop more quickly than others. The law of negligence, as it applies to public authorities, is one aspect of the common law which has seen significant development, in particular in a run of 3 cases in the Supreme Court in the second half of the last decade. Perhaps because there is an almost infinite supply of potential factual scenarios to which allegations of negligence may be levelled at public authorities, the cases continue to come thick and fast. The latest instalment is the case of Tindall and the Chief Constable of Thames Valley Police, a decision of the Court of Appeal handed down in January of this year, in which the court allowed an appeal against the decision of Master MacLeod to refuse the Chief Constable's application to strike out the negligence claim brought by Mrs. Tindall. In this seminar, I intend to look in detail at that decision and the reasoning of the court, and to analyse where the decision fits within the direction of travel shown by the recent case law. The facts of Tindall are tragic. Mrs. Tindall sued as the personal representative of her late husband Malcolm, who died in a head-on collision in March 2014 when the vehicle he was driving hit a patch of black ice on the road. He lost control and came into a head-on collision with another driver, Mr. Bird. Both men were killed. Around an hour prior to Mr. Tindall's accident, another driver, a Mr. Kendall, had slid off the same part of the road on the same black ice and suffered injuries. Mr. Kendall worked as a road gritter locally, and he was concerned that others might suffer the same fate as he had. Whilst waiting to be rescued and attended by an ambulance, he stood by the road and warned other oncoming vehicles to slow down. Around 20 minutes after Mr. Kendall's accident, the police arrived at the scene. They put up a "Please slow" sign and removed the debris from the road. They stayed for around 20 minutes, and whilst they were there, an ambulance attended which took Mr. Kendall away to hospital. It was accepted for the purposes of the application that if the police had not attended, Mr. Kendall would have continued to warn road users of the dangers of black ice, and it was also accepted that the police did nothing to positively encourage or compel Mr. Kendall to leave the scene in the ambulance. After Mr. Kendall had gone off to hospital, the police left the scene, taking their sign with them and taking no further steps, either to make the road safe or warn drivers of any impending danger. It was around 20 minutes after the police left that Mr. Bird and Mr. Tindall came into collision. Before we look at the way in which Mrs. Tindall put her claim, it's useful to remind ourselves of an important distinction the law makes in the field of negligence liability between acts and omissions and what has been termed the duty not to make things worse and the duty to protect someone from harm. Since the House of Lords decided the case of East Suffolk Rivers Catchment Board and Kent in 1941, 3 propositions have been settled law. First, that public authorities are to be treated no differently to private individuals for the purposes of the law of negligence. Second, generally, and subject to some important exceptions which have been developed through the case law, person A is not subject to any duty to take care to prevent harm occurring to person B through a source of danger which is not created by person A. And third, where an individual or public authority comes across a source of danger which it has not created, but performs a positive act which makes that danger worse, it will be liable in the tort of negligence for harm caused by its actions in making that danger worse. The limitations of the duty not to make things worse was made clear in the East Suffolk case. In that case, a sea wall was breached at high tide, which caused flooding to the plaintiff's land. The defendant authority undertook repairs to the wall, which took 178 days to complete, but which, the trial judge held, could have taken only 14 days if the public authority had been so minded. In holding that the claim against the authority for the damage suffered as a result of the delay to the repair was bad, the House of Lords held that where, in the exercise of its discretion, a public authority embarks upon execution of a power to act, the only duty owed to members of the public is to not thereby add to the damage which the person would have suffered if the authority did nothing. That is the limit of the duty. Mrs. Tindall claimed that the Chief Constable, who was vicariously liable for the acts of their officers who attended shortly before her husband's accident, was in breach of his duty not to make things worse and his duty to protect Mr. Tindall from suffering harm. The allegation of the breach of duty not to make things worse was that the actions of the police in attending the accident led to Mr. Kendall leaving the scene, and that if Mr. Kendall had stayed, it was likely that he would have warned drivers to slow down as they came past, including Mr. Tindall, and so the fatal accident would have been avoided. So Mrs. Tindall said, the attendance of the police made things worse. The allegation of breach of the duty to protect Mr. Tindall from harm encompassed several allegations, including a failure to conduct a risk assessment, a failure to take steps to slow traffic down, a failure to take all reasonable steps to get a gritter to attend prior to Mr. Tindall's fatal accident, failing to stay at the scene, and failing to close the road. As can be seen, all of these allegations were allegations of omission. The Court of Appeal conducted a thorough survey of the authorities in the area, including a very useful analysis of the trilogy of cases heard in the Supreme Court in the mid to late 2010s. Michael and the Chief Constable of South Wales Police in 2015, Robinson and the Chief Constable of West Yorkshire Police in 2018, and N and others and Poole Borough Council in 2019. The focus in all of those cases was on the exceptions to the general rule that person A is not liable for preventing harm to someone which arises from a source of danger they didn't create. In Robinson, Lord Reid had cited with approval the following pithy summary taken from a 2016 article by Stelios Tafaris and Sandy Steele, published in the Cambridge Law Journal. And I quote, "In the tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of danger not created by A unless 1. A has assumed a responsibility to protect B from that danger. 2. A has done something which prevents another from protecting B from that danger. 3. A has a special level of control over that source of danger. Or 4. A's status creates an obligation to protect B from that danger." The issue of assumption of responsibility was at the forefront of the court's consideration in the case of Poole. In that case, 2 children had been placed together with their mother by the local authority in a property under its powers as a housing authority. The property into which they were placed was located next to a family which the local authority knew was liable to behave in an antisocial and harassing manner. The claim of the children for damages suffered as a result of the behaviour of the neighbouring family failed because, as Lord Reid put it, and I quote, "The assumption of responsibility is an undertaking that reasonable care will be taken, either express or more commonly implied, usually from the reasonable foreseeability of reliance on the exercise of such care," close quotes. Lord Reid found that in placing the children in the property, the local authority was not assuming responsibility to provide its service of housing provision with reasonable care. His reasoning was rooted in the absence of reliance, and I quote, "In the present case, on the other hand, the council's investigating and monitoring of the claimant's position did not involve the provision of a service to them on which they or their mother could be expected to rely. It may have been reasonably foreseeable that their mother would be anxious that the council should act so as to protect the family from their neighbours, in particular by rehousing them, but anxiety does not amount to reliance. Nor could it be said that the claimants and their mother had entrusted their safety to the council, or that the council had accepted that responsibility. Nor had the council taken the claimants into its care and thereby assumed responsibility for their welfare." Close quotes. In Tindall, the Court of Appeal gathered together the principles in relation to the negligence liability of public authorities in what I think is likely to prove a user-friendly and oft-cited passage. They said as follows: 1. Where a statutory authority, including the police, is entrusted with a mere power, it cannot generally be made liable for any damage sustained by a member of the public by reason of a failure to exercise that power. In general, the duty of a public authority is to avoid causing damage, not to prevent future damage due to causes for which they were not responsible. 2. It follows that a public authority will not generally be held liable where it has intervened, but it has done so ineffectually, so that it has failed to confer a benefit that would have resulted if it had acted competently. 3. Principle 2 applies even where it may be said that the public authority's intervention involves it taking control of operations. 4. Knowledge of a danger which the public authority has power to address is not sufficient to give rise to a duty of care to address it effectually or prevent harm arising from that danger. 5. Mere arrival of a public authority upon or presence at a scene of potential danger is not sufficient to found a duty of care, even if members of the public have an expectation that the public authority will intervene to tackle the potential danger. 6. The fact that a public authority has intervened in the past in a manner that would confer a benefit on members of the public is not of itself sufficient to give rise to a duty to act again in the same way. 7. In cases involving the police, the courts have consistently drawn the distinction between merely acting ineffectually and making matters worse. 8. The circumstances in which the police will be held to have assumed responsibility to an individual member of the public to protect them from harm are limited. It is not sufficient that the police are specifically alerted and respond to the risk of damage to identified property or injury to members of the public at large or to an individual. 9. In determining whether a public authority owes a private law duty to an individual, it is material to ask whether the relationship between the authority and the individual is any different from the relationship between the authority and other members of the same class as the individual. Mrs. Tindall relied heavily on a Scottish case, Gibson and All. In that case, following a bridge collapse after heavy rainfall, the police attended and coned off the north side of the bridge, illuminating their headlights and the blue lights of their vehicle so as to warn those approaching from the south side. However, the police did not take any steps to cone off the south side of the bridge and left the scene. A passenger in a car which drove off the edge of the south side of the bridge sued. The Lord Ordinary held that a duty of care was owed to the passenger in those circumstances, relying upon an analysis rooted in the Caparo and Dickman test, and in particular, the Lord Ordinary's view that the police had assumed responsibility for the safety of the road either side of the bridge upon their attendance. Now, it's difficult to see how this decision in Gibson and All could be squared with the duty not to make things worse, or the circumstances in which public authorities may be held to have assumed responsibility that they will perform their functions with reasonable care, as was explained and clarified by the Supreme Court in the trilogy of cases I have referred to. That too was the view of the Court of Appeal in Tindall. They disapproved Gibson and All, and with it probably went Miss Tindall's best point. When it came to the application of the law to the facts in Tindall, the Court of Appeal held that the master had been wrong not to strike out the claim. Even taking the facts at their height, there could be no duty of care owed by the Chief Constable. In relation to the allegation of breach of the duty not to make things worse, the Court of Appeal found that the mere attendance of the police was insufficient to establish such a breach. On the facts, the police had done nothing to persuade or compel Mr. Kendall to leave the scene, and so could not be held liable for the consequences of his leaving. As to the claim based on the breach of the duty to prevent harm, the Court of Appeal held that on conventional principles, these were allegations of a failure to take care to prevent harm caused by a danger created by someone other than the Chief Constable. The general rule, therefore, was that no duty arose. The Court of Appeal explicitly rejected the submission made on behalf of Mrs. Tindall that a duty could be imposed where the police had the power to exercise physical control over the accident locus, but failed to do so. None of the established exceptions to that general rule applied in this case. So what of the direction of travel? Well, we now have a clear framework within which the courts are to decide whether a public authority owes a duty of care to members of the public. The touchstone remains that, save in closely limited circumstances set out by the case law, a public authority will owe no duty to members of the public to prevent them from suffering harm which the public authority did not create. The exceptions to that general rule are likely to provide fertile ground for future litigation. For instance, Lord Reid's explanation of the role of reliance in analysing whether a public authority has assumed responsibility to provide a service with reasonable care appears to me to be an aspect which needs further clarification. However, there is no doubt that Tindall represents a clear restatement of the general principle. It also provides useful guidance on the duty not to make things worse, and for the lawyers, it gives us, in the 9-principle checklist in paragraph 54, a handy précis of the principles which have been developed in the law in this area over the last 100 years. Thank you very much.
Hello, my name's Shada Mellor and I'm a civil liberties and human rights practitioner here at Trinity Chambers. My talk today is on the Miscarriage of Justice scheme. What is it? Well, it is what it says on the tin. Compensation for miscarriages of justice, which is provided for in section 133 of the Criminal and Justice Act 1988. The relevant provision states that when a person has been convicted of a criminal offence and when subsequently his conviction has been reversed or has been pardoned on the ground that a new or newly discovered facts show beyond a reasonable doubt that there has been a miscarriage of justice, the Secretary of State shall pay compensation for the miscarriage of justice to the person who has suffered punishment as a result of such conviction, or if he is dead, to his personal representatives, unless the non-disclosure of the unknown fact was wholly or partly attributable to the person convicted. The remainder of section 133 unpacks this rather convoluted and long provision. Before turning to unpacking the phrases within that provision, perhaps I'd like to turn to provide a little bit of background. Article 14.6 of the International Covenant on Civil and Political Rights, which was ratified into the United Kingdom in May 1976, required state parties to compensate those who have suffered a miscarriage of justice. Section 133 is given effect to that. Section 133 wasn't always as I have read out to you. In fact, a new definition was included by the Antisocial Behaviour, Crime and Policing Act 2014, Section 175. The reason for doing so was that there was a significant body of case law which had been developed since the provision initially was put in place. In effect, there was considerable judicial disagreement and the goalposts kept moving. Therefore, the inclusion of the new definition, it was hoped, would provide some clarity. It has not done that at all. In fact, could say that it's only escalated the disagreements. And in fact, those disagreements are no longer confined to the domestic courts. Currently, we are waiting on a case to be heard in the European Court of Human Rights on whether the provision is compatible with Article 6.2 of the European Convention of Human Rights, that article being the presumption of innocence. Turning then to unpacking section 133. The first phrase being, his conviction has been reversed or pardoned. Reverse being that the conviction has been quashed, either on an out of time appeal or on reference under certain statutory provisions. In a case in which the person's conviction for an offence has been quashed on appeal out of time and the person is subject to a retrial, the conviction is not to be treated for the purpose of the section as reversed until the person has been acquitted at the trial or the prosecution indicate that they are not seeking to proceed with a retrial. I don't propose to cover pardons as one would expect they are relatively rare. The next phrase to unpack is new or newly discovered facts show beyond a reasonable doubt that there has been a miscarriage of justice. What do we mean by there has been a miscarriage of justice? Well, what that means is that it must be shown beyond a reasonable doubt that the person did not commit the offence. This is the section which we can call the hot topic at the moment, in which we are waiting for the judgment from the European Court of Human Rights as to the compatibility of that requirement with Article 6.2. There have been two recent and very important cases in this area. Firstly, the UK Supreme Court case in 2019 of Hallam and Nielsen and the Secretary of State for Justice. Those were the conjoined cases of Mr. Hallam and Mr. Nealon, who had spent 7 and 17 years in prison respectively. These gentlemen's convictions were quashed for being unsafe, on the ground that had the newly discovered evidence been before the jury, it may have created the possibility of an acquittal. Following their release from custody, both applied for compensation under the Miscarriage of Justice scheme. And the Secretary of State for Justice refused their applications for compensation on the ground that the new evidence did not show beyond a reasonable doubt that they had not committed the offence. They both challenged this decision by way of judicial review, and both the Divisional Court and the Court of Appeal refused to make declarations on incompatibility. The case ended up in the Supreme Court, and by way of a 5-2 majority, the court dismissed the appeals. In the lead-in judgment, it was said that Article 6.2 was not engaged. However, it is important to note that in the concurring judgment by Lady Hale, she stated that it was, in her view, that Article 6.2 was engaged. And it was not clear that if the question was put before the court, whether the European Court of Human Rights would find that the test was incompatible. Additionally, this was a case in which the court overturning the conviction expressed that the newly discovered evidence might, had it been put in front of a jury, have created the possibility of an acquittal, which is not the same as showing beyond a reasonable doubt that the person did not commit the offence. All the judges expressed views that the case law on this point is confusing, and that includes both the domestic and Strasbourg's case law. This is the case which the European Court of Human Rights will opine on soon, and at that point we expect to have a conclusive answer whether the test is incompatible or compatible with Article 6.2. The second case is R on application of K v. the Secretary of State for Justice. In this case, the claimant was convicted of rape and sentenced to 4.5 years in prison. At the trial, the jury was shown some text messages. The claimant insisted throughout the trial that those text messages were incomplete, and numerous requests had been made to the Crown Prosecution Service to source the missing messages. However, this was not done. The claimant was convicted. Following his conviction, the messages were obtained in full by his family. The claimant then appealed his conviction to the Court of Appeal. The Court of Appeal had sight of the full exchange of the messages, and in their judgment they stated that it was clear that the complainant had manipulated the sequence of the messages, and that the evidence raised reasonable doubt regarding his conviction, thus rendering it unsafe. No retrial was sought by the Crown Prosecution Service. The complainant then made an application for compensation under the Miscarriage of Justice scheme, which was refused by the Secretary of State for Justice. The claimant sought judicial review on the ground that the test was indeed satisfied, and as well breaches of Article 6 and 8. Turning to whether the test had been satisfied, the court said that the fact that the social media records had been manipulated was obviously material to the jury's assessment of the respective credibility of the complainant when considering whether it could be sure that the offence had been committed. However, the instant case was not an extreme case in which the effect of the newly discovered evidence meant there was only one rational correct conclusion as to the result of the application of the statutory test, namely that the defendant was innocent beyond a reasonable doubt. For compensation to be payable, the newly discovered fact had to positively disprove the commission of the offence beyond reasonable doubt, and not merely undermine the safety of the conviction. As to whether Article 6.2 had been engaged and breached, the court followed the Supreme Court judgment and stated that Article 6.2, which provided for the presumption of innocence unless an individual was proved guilty according to the law, was not applicable to the operation of Section 133. And in any event, Section 133 was not incompatible with Article 6.2. As to their view on Article 8, in which the claimant claimed it had been breached due to the failure to pay compensation and the effect on his reputation, the court called that argument unsustainable. Turning to the next element of the test, who has suffered punishment. The statutory provisions state that suffering punishment as a result of the conviction is when the sentence was passed on him for the offence for which he was convicted. We then have unless the non-disclosure of the unknown fact was wholly or partially attributable to the person convicted. This appears to be a case-specific test. I then turn to the next section of this talk, which is the application for compensation under the Miscarriage of Justice scheme. An application for compensation must be made to the Secretary of State within 2 years beginning with the date on which the conviction was reversed. The Secretary of State has the discretion to extend the time limit, however, only if there are exceptional circumstances for doing so. Again, this appears to be solely at the discretion of the Secretary of State. It is the role of the Secretary of State for Justice rather than a court to determine if there is a right to recover compensation. If such right is found, then the amount of compensation is to be assessed by an assessor appointed by the Secretary of State for Justice. Finally, turning to the assessment, as I said, it an assessor will be appointed by the Secretary of State for Justice, and the Secretary of State for Justice has no input in relation to the quantum. The assessor will determine the amount of compensation payable for suffering, harm to reputation or similar damage with consideration to A, the seriousness of the offence which the person was convicted and severity of the punishment suffered as a result of the conviction, and B, the conduct of the investigation and prosecution of the offence. Once the above assessment has been made, the assessor is then entitled to make deductions from the amount for A, any conduct of the person appearing to the assessor to have directly or indirectly caused, contributed to the conviction concerned, and B, any convictions of the person and any punishment suffered as a result of them. If the assessor considers there are exceptional circumstances for doing so, the assessor is entitled to determine that the amount of compensation payable is nominal amount only. There are, as you may expect, caps on the amount of compensation which can be recovered. For those who have been detained for 10 years or more, the cap is £1 million, and for all others, the cap is £500,000. Compensation for loss of earnings or earning capacity is also recoverable. As you may expect, there is also a cap on this. In a 1-year period, it must not exceed the limit, that limit being 1.5 times the median annual gross earnings according to the latest figures by the Office of National Statistics. Thank you.